Oyez, oyez, oyez. All persons having business before the Honorable the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention. For the court is now sitting. God save the United States and its honorable court. Be seated, please. Case number 25-1150, ModernWest Longmont, LLC, Petitioner versus Federal Aviation Administration. Mr. Goldberg for the petitioner and Ms. Lopez for the respondent.
Morning, Your Honors. May it please the court, Roy Goldberg on behalf of the petitioner, ModernWest of Longmont, LLC. I would like to reserve 2 minutes for rebuttal. This case presents two different looks at our Federal Aviation Administration. On the one hand, we had the portion of the FAA that handles airport obstruction and analysis, and they dedicated the usual large number of key staffers, and they determined that this mixed-use development proposed by ModernWest in Longmont, Colorado, did not present a hazard to air safety. On the other hand, we have an FAA Airport District Office Manager, local in Denver, who paid no attention to what the large assemblage of the FAA side, the safety side, had decided, and concluded on his own that it would violate federal grant assurances if Longmont allowed the mixed-use development to happen. When that official, John Bauer, was repeatedly asked to provide an explanation for why this proposed development would not be compatible with airport operations, he just refused to do so, as did the Office of Chief Counsel and its Airport Law Division. This is a classic case of arbitrary and capricious conduct. No reasonable explanation was provided for the action taken. The case calls to mind the court's ruling in Butte County versus Hogan. That decision relied on the Melville story, Bartleby the Scrivener, who was asked, could you do some work for us? And he said, I prefer not to. That was his explanation. And in this court also found in Butte County that wasn't sufficient for the Interior Department in that case.
What's your standing here?
Standing, Your Honor, is because as of the final order, the refusal to withdraw these letters, the final order was April 30th, 2025.
What are you perceiving to be a final order as a legal matter? Not your characterization.
Sure. The reason why the April 30th email is it said, finally and determinative, we don't accept what you're asking for. We don't accept that the letters need to be withdrawn. Don't talk to us anymore. This is our final decision. We'd asked them 3 or 4 times to the Office of Chief Counsel, these letters are unlawful. Explain to us why they're lawful, but because you can't, they need to be withdrawn. And in that letter, they refused to do so. So that's a final order. It had legal consequences because my clients who had received both approval from Longmont for ModernWest 1, and then were very close to getting approval from ModernWest 2. And then all of a sudden these letters come out. That's why we call them poison pill letters, and everybody pulls back. And the Longmont refuses at that point to give any type of relief or to allow the zoning to go forward.
So if you got something back from them that said, oh, we got your most recent note. Yeah, we're with you. Good luck. That changes the circumstance you're in?
If they had withdrawn the letters, it would have totally changed the circumstances, Your Honor.
How do we know that?
Because
how do you know what the city would have done? I'm sorry for interrupting.
No, it's a great point.
Time is short.
No, we want to get right to this. It's important. We think that this argument is just it's a procedural argument that the FAA is making because they can't win on the merits.
I'm making the argument.
Right. The reason why it is because there's no real speculation. This is, with all respect, Your Honor, your case of the wrestling case. In the wrestling case that you're talking about, the Department of the Education never went to Bucknell University and said, if you let these guys wrestle, we're pulling all your funding. But that's what's happened here. These letters said, if you allow this to happen, you will lose funding from the grant assurances. And it's very important for this airport. And the idea that somehow...
Wait.
Sure.
Let's go back a little bit. You have 3 approvals you have to be able to be in the position you want to be in. City, state, and FAA.
Right.
Your argument essentially is if we have the FAA, we have all the relief that we need. That's not true. The city has reasons that have nothing to do with the FAA. At least they state reasons that have nothing to do with the FAA. That's one of the things, but they state other reasons why they're taking the position. So how do you, either on standing terms or otherwise, it's a weird characterization. How do you get around that? To win as you want to hear doesn't get you what you want.
Up until these letters, Your Honor, the city was approving this every step of the way. The letters
City
happened.
and,
Right.
bear with me, the city and state have not given approval.
The city
There's
was,
nothing to indicate the state's going to waiver depending upon what the FAA in response to your email does.
as reflected in our papers, the state is not a real player here, Your Honor. We're talking about how much money goes from the federal government, which is millions of dollars. The state is an add-on at one point. And Your Honor, let me ask you to take a look at in here a particular letter from the city of Longmont. It is JA 207, right around the key time frame. It's September 25th, 2024. They say, in this instance, the FAA's determination of adverse impacts on airport operations constitutes a significant factor warranting further review. In other words, they're pulling the process because of the FAA. In the real world, nobody is doing anything because of the CDOT, Your Honor. That was an add-on. It has no real world significance. When you're a city official and the FAA come and tells you, if you allow this development, you will lose funding, that's full stop. That's coercion. That's determinative. And there's nothing else out there that matters. That's the key play here. And Your Honor, interestingly enough, the word on coercion, because that's part of the case law here, if you actually go back to, and it's in the record, it is 341, JA 341, back in May of 2023 rather, one of the counselors for the city of Longmont actually says there, and this is JA 341 on the record, it just feels like coercion. She's talking about the FAA, the first FAA letter from June 2023. So we believe this, the record here clearly shows that there is coercion.
Is the heart of your argument that if you win on your claim against the FAA in this case, the city must fold or they guaranteed will fold? I'm not reading the record that way.
We want the letters withdrawn, Your Honor. That's the relief we're seeking.
Well, how do you, and I don't understand the standing then. If that's really all you're asking for, you want the letters withdrawn, isn't that the city's fight?
No, the city is
I
neutral.
understand your interest, but
Right.
I don't know how you can be here if that's it. We just want those letters withdrawn.
Before the letters were withdrawn, we were doing the development. We were getting the approvals we needed. We withdraw the letters, the city no longer.
And if you get it withdrawn, there's no guarantee the city's going to change its mind.
Well, we know where the city was before the letters came in, which is they were approving it.
And I think this gets to the key difficulty, right? If you represented the city, this would be very straightforward. But we need to speculate about what the city would do. And what would be very helpful would be if there was evidence that the city still supports your projects. So in the DNF Afonso case, they got some of the city officials to put in affidavits and we said, great. And one difficulty for your position here is you don't have evidence of that type. So how can we infer that the city still supports your projects?
Well, we do have evidence, Your Honor. Thank you for the question. It's a 341 where Hidalgo, one of the counselors, said, I feel coercion because of the FAA. We know that the FAA approved this process.
So one way to support your standing would have been to go to that council member and ask them, there's a predicate question of why the city isn't a party to the suit if it supports you, but you go and you ask them for an affidavit. And then we'd ask, well, that's just one city council member. How do we know what's going to happen? And it is a tough position, but our cases say it is a tough position when you rely on the actions of a third party.
But when there's no speculation here. They were approving. We had the approval for ModernWest 1. We were very close to ModernWest 2. That's very different than, for example, the National Wrestlers case. As far as the city goes, their regulator is the FAA. The FAA controls the money. And it is not realistic, Your Honor, with all due respect, to think that they're going to take the dog in the fight of the developer that is not even part of
I
FAA
totally
regulation.
agree with that. They certainly could say, we're not picking a fight with the FAA, but if the FAA withdraws these letters, we care about affordable housing and we are going to support this so long as the FAA withdraws this.
Well,
it's a 3-sentence declaration.
Actions speak louder than words, and the actions are they approved it until they didn't. And one other thing, Your Honor, it's in the record. The relatively new airport director, Levi Brown, who was very much part of the pilots coalition that wanted the airport to be used for that and not have the development. Now, he decided he needed to go to the FAA in June of 2023 in Denver and ask them to write that first poison pill letter. If he thought that the city was on the fence or was not going to go ahead and approve this, he wouldn't have needed to do that Hail Mary, but he did, because he knew what the facts all show here, which is this thing was getting ready to be approved until something happened. And what happened were these letters that completely ignored what the FAA side of that non-hazard side of the building had done. And more importantly, we asked John Bauer, please explain why this is incompatible. Maybe we can learn from that how to make it compatible, but he refused.
So here's I know they haven't been as specific as you'd like, but the FAA has now said in various ways, the concern here is, even though you're not obstructing flight paths, if a accident happens, having an apartment building near the runway increases the consequences, and there might be noise litigation. And is there any evidence that the city thought about those concerns and had concluded, we're not worried about that? In other words,
Sure.
One read of this record that would be unfavorable to you is just, it had not occurred to the city that in the event of an aircraft accident, you don't want a high density apartment building there. And so now they are, on a prior position on that to return to.
But that now we really are getting into speculation that the government accuses us of. I mean, this was going along. It was fine. We have in the record, so it wasn't like we're just saying it. We have the capital engineering report that refers to, I don't know, is it 20 other airports with similar situations that have been allowed? And that's why FAA has dug a hole they can't get out of. They can't go back on remand or otherwise and say, well, this is incompatible, because if they do that, then they will be admitting all these other airports are incompatible. So they tried to do a very narrow thing, which is to stop this in its tracks, but not tell us why, refuse to tell us why. And it's just kind of the arrogance of power. Like, we're the FAA, we control the strings of money here, and we can tell these people not to do it, and they won't do it. And we just think it's very arbitrary.
This is all very helpful.
Go ahead.
I just had one last question, sure. Which is, be helpful to hear you respond to the following, which is, speaking of limited authority, we have limited authority in this instance. We can order, I think the best you can hope for from us is an order that FAA withdraw its letters. Mm-hmm. We can't order them to say there is no incompatibility. No. We can't even order them to reissue letters. So nope. In one view, the best you can hope for is the FAA is these letters are withdrawn, but everyone's still left in the dark about what the FAA thinks. And how do you?
No, that helps. That helps a lot, because, right now, if you're the government official in Longmont, all you've got is the FAA saying, you allow this, your funding, is going to be taken away, or there's a significant chance it's going to be taken away. And you can't allow that as the local person. And I get that. Once those letters are taken away, then that means that the Longmont people no longer have an empty chair to blame. They can no longer say our hands are tied. At that point, they're subject to whatever due process requires for a property owner. And that's fine. We just want to take out this false elephant in the room, which is the FAA letters. It's not fair what they've done. The FAA letters should be removed. At this point, it's in the record that at least it's strongly suggested that FAA told Denver to stop issuing those letters, and they stopped. The one thing we're trying to seek from this court, Your Honor, is to ask the FAA to withdraw letters that are arbitrary and capricious, should never have been issued. Judge Pillar.
I had a couple of questions that are sort of concrete. Judge Garcia asked you about noise and about the residential density. I thought there was an assurance that there would be no, basically that whoever's going to be using this building has agreed they're going to put up with the noise.
Absolutely. Very strong navigation easements. Nobody can go into that building without agreeing. We're coming to an airport. We understand an airport's there. We're not going to wake up tomorrow and say, oh my gosh, there's noise, there's gambling going on. We're shocked. Yeah. That is covered. And no question.
I took the concern to be really about the residential density, and you opened by talking about how these had already been approved as safe, the Part 77 no hazard determinations. But I understood there to be two different kinds of inquiries. One is the FAA doing the no hazard determination, which is basically saying, where our planes need to go, can we clear whatever's in the way? And they found that they could. But then there's a separate inquiry, which has to do with the locality, and sort of looking at its interests, its people, which is, interacts with the FAA's expertise, but it's ultimately this local zoning question, and that had not, that the question whether they had considered the residential density was, less clear than the noise question.
Well, we did, it's JA 84. There's a letter from our client on July 16, 2024 to Mr. Bauer that says, okay, we understand you're claiming safety, but we ask therefore, what is the standard for compatibility that is being violated? In the absence of an FAA standard, compatibility could arbitrarily be determined. It could differ from project to project and airport to airport based on the subjective judgment of the FAA official who happened to be involved. That's our case. This is
And they
subjective.
say, there's this advisory circular and talks about density, local regulation of concentrations of people. What is arbitrary about the city saying, we hadn't really thought about that. In fact, it's almost as if the city's making the same conflation that you were. Well, FAA in the Part 77 no hazard determination has told us this is all safe, but without focusing on their responsibility, not for the planes and the people on the planes, but for the people on the ground and the residents.
There's no evidence that the city came to that or said, oh my gosh, we didn't know about that. Quite the contrary, Your Honor. In JA 335 to 341, this is what I was talking about before. Judge Garcia mentioned this is from the May 7, 2024 meeting of the planning board there, where, you can see the officials, including Ms. Apperson, the planner, basically saying, we've never seen the FAA do this before. We've never in our lives been threatened with these letters. It's our airport. We're usually able to do what we want. So this was all very new to the city, but certainly in the time frame before the Bauer letters, they knew what the city was claiming. There just was nothing substantive put behind it. And again, when you refer to advisory circulars or whatever, that aren't even part of our record, I mean, that's just appellate counsel saying, theoretically, maybe if I'd been at the FAA, I could have worked with these documents. We could have done it that way. But that's not what they did. They were coy. They didn't want to give us the reasons. They didn't want to give us a final order, Judge Edwards, but sometimes you have to say we need a final order because we're not going to just keep. And the final thing, Your Honor, I'm well over my time, is that it's not like we were in a position to do a Part 16. Those take many years.
Clear in my mind,
Sure.
what you're saying. A final order with respect to what precise matter?
Withdrawal of letters.
Huh?
Withdrawal of arbitrary and capricious
No,
letters.
what precise substantive issue is it that you think the FAA has adjudged in a way that's adverse to your interest that you want removed? In other words, a normal agency case, the issue is X, the parties fight over it, the agency says X plus 1 is the answer, and that's what comes to us. Were they right in X plus 1 or not? What you're fussing about the exchange of emails, and one of the problems for me as a judge is trying to figure out, well, wait, who's challenging what's on the table, and what is it that you think is offending here?
Yeah, I think I can answer that in two ways. First of all, what we think is offending, to be clear, are the Bauer letters, the incompatibility letters. We asked they be withdrawn. The FAA refused. That's the final order. But to your point, Judge Edwards, I did cite a case that was my case. We had Judge Williams. I don't think anybody else from this panel, back in 2014, called Security Point Media versus TSA. And, counsel for the FAA tried to say that was in opposite for some reasons. But the reason why it was very similar, and I remembered it, is because Francine Kerner at the TSA was angry that my clients had brought a patent infringement case against the government. So she basically took indirect orders that required airports to sign new license agreements for my client's patent. And once again, she refused to do a final order. Finally, we sent a letter to her and said, Chief Counsel Kerner, justice delayed is justice denied. We would like you to, just to tell us you're not going to do anything about how you're messing up, frankly, with our contracts at these airports. She finally did send a letter that said, I'm not changing my position. That's my position. And Judge Williams did find that was a final order because basically a business had come to the court and said an agency, it was TSA here, it's FAA, is interfering with our business. They're overstepping. They're basically unhappy about something, so they're taking a shortcut to hurt us. And Judge Williams found that was the case there. I mean, if you see the opinion, it's in our papers, Security Point Media, and that's what's happening here. John Bauer just decided to take a shortcut. He was tired of all the noise litigation. He was tired of various things that are happening in Colorado, and he realized that he could send some strong letters and he could accomplish what really should have been accomplished through an arbitrary and capricious type of, something where we can present evidence and the FAA would actually have to come out and say, here is why it's incompatible. Not, oh, well, it's one thing to say, well, you've got some multi-use development near an airport. In theory, okay, we understand that. But in specifics, what does that mean to a developer who is trying to build something?
One way that Security Point seems a little bit more straightforward is that the TSA actually did change the contract template, the memorandum of understanding,
Yes.
whereas in this case, they're purporting to be applying the prior standards, the agency, the advisory circular, and just say, look, this is a separate thing from the hazard, the Part 77 no hazard determination. And so it rather than seeming like a new restriction, it's bringing to bear a pre-existing restriction. So I'm interested in your reaction to that, and just generally, what is the precise legal consequence, the second part of the finality inquiry that we should identify from the April 30th email?
Sure. Well, thank you very much. On the second point, we've had the property since 2017 or before, started the process. As of today, nothing's been built. That is harm. That is injury. It's not recoverable.
Understanding. I'm talking about legal consequences that flow from
We can't build.
From the letter.
We can't build. Because the letters are a poison pill that any sane person in Longmont would not allow this to
It's
go.
a poison pill, but what is the legal consequence, and what's the case that is closest in terms of, there's a practical consequence for sure.
Right.
But, that we have a lot of finality cases that deal with this question about whether rights or duties have been affected or legal consequences flow. And I'm just seeking sort of the most precise you can be on what.
And Security Point, while you're answering, Security Point essentially is announcing a new policy, which was the challenge in that case. That's why I'm trying to figure out what you're trying. This is not a Security Point case.
Okay. Well, I think that, Judge Pillard, the one thing I'd say is the arguments you were making about this compatibility issue, those are all post hoc. We never got a letter from the FAA that said, go look at this advisory circular, or here's how we imply it. This is something the council has pulled out. Not to us, they didn't.
But you're claiming, you're the third party. That's where it's sort of difficult. What if there were contemporaneous back and forth between the city and FAA on this question? Is that a Chenery problem or not? If at the time they were making the decision, these were the concerns that were being raised.
It's very clear in the record, as I mentioned, and I quoted during oral argument, Your Honor, that the city in September said, we're pulling the plug because of these letters. That is very clear. They got the letters from John Bauer and they stopped the process. That is what's in the evidence.
So it's contemporaneous. And if the reason for doing that is looking back at the advisory circular and thinking about the safety to the townspeople as distinct from, or the city folk as distinct from the safety of aviation as such,
Maybe if the
that's
Bauer,
neither post hoc nor arbitrary.
maybe if the Bauer letters had done that, Your Honor, and we would have had something to aim for and understand, but the Bauer letters say nothing of that fact. They just say what you're doing. There's a letter September 17th, it violates grant assurance, and then they pull it back and say, actually, we misspoke. It's our view that it violates the grant assurance. That makes a difference. In the real world, it does not. And so, but I do think this
take from that the shift from that's trying to be.
It doesn't mean anything.
Not interfering, but you sort of chuckled because you.
Well, because they thought it made a difference.
Shady about that.
Well, not shady, a little too cute, a little too coy. The bottom line is when you are a sponsor of a federal airport, especially one like Longmont that really needs Vance Brand the money, and the FAA says, you're going to do this and we're going to take the money away. There's no discretion. It's coercive. It's determinative, and There's no real argument
You think
otherwise
there's a
here.
ruling from the FAA that says, if you do this, we will take the money away?
That's what those letters say, yes.
That's your surmise, or do they say that?
They say that you'll violate Grant Assurance 21, and everybody knows the only thing that happens if you violate Grant Assurance 21 is ultimately all your money, both what you received before and going forward, can be taken away. That's the one thing that the government has. And they know that, and the city of Longmont knew that. And again, if you look back on the 2024, this again is JA 335 to 341, with a transcript of the Longmont City Council study session. You can see their shock really at these FAA letters, which is a new thing.
I'm sorry, what pages did you just cite?
Sure, Your Honor, it's JA 335 to
Okay.
JA 341. Actually, 42. 41 is the one where the Hidalgo said, I don't know, it seems like coercion, talking about the FAA letters. But Jennifer Hewitt Apperson is the principal planner there, and she talks about here how, this is all new from the FAA. They're not used to this type of pressure or them telling them how to run their airport. So it's not like it's some standard that's been out there and it's just business as usual. I mean, this was a shift. And it's really undisputed is what the FAA was doing. And we tried to find out what it is that made this incompatible in the view of the FAA official. And he refused to tell us, which is arbitrary and capricious. And, I think that this is not like we just came out of the woodwork. We want to be at the airport. This was in the works for a long time. It was happening. The airport director did a Hail Mary by going to the FAA because he knew it was going to happen otherwise if he didn't. And the thing that is similar to Security Point Media is the fact that what Francine Kerner and the TSA were doing there was having an impact. And it was causing Security Point Media to have problems getting their carts and trays method into airports. So yes, it was a change because they were unhappy that we had sued the TSA, but ultimately it was kind of an end run, kind of a pressure campaign that the TSA was doing with airports. It was inappropriate. And again, thank you for your time. Well over my time, but it's inappropriate with these letters.
I think all you can read, I'm looking at them, read in those emails, the FAA is suggesting, take the worst of it, that if this proceeds, we can act against you. They're merely sending an email is not a final disposition of what they could or would do. They don't have that authority. They have to invoke procedures to put that Assurance 21 in play. You can't have someone in Washington just sending an email saying, we've revoked it. That's not the way it works.
No, they would have to file, which they can.
All right, so there's nothing like that on the books. So you have someone in Washington sending something saying, well, if you do that, we'll what? You can't find the person who was writing you didn't have the authority to make the final disposition that the FAA might have been able to make. So that's one of the things that's bothered me all along. You don't have a final disposition from the FAA. I think it's an obnoxious exchange that's going on. It makes no sense. We shouldn't be doing business that way, but you don't have a final disposition.
It's final. We asked for the letters to be withdrawn and they said no.
They can't make it final that way. So even if someone says we might act against you, that's not a disposition of the issue, because we might act against you merely contemplates the possibility you could win or lose if they do act against you.
No, I totally respect what you're saying, Your Honor, but in the Part 16 world, these cases take 4 years or so, and no responsible airport official is going to say, we'll roll the dice. Yeah. Once they were told this is going to violate Grant Assurance 21, their hands were tied. The only relief we can get here, and it's not fair to say that there's nothing we can do because there's a Part 16 and it doesn't apply to you. These letters were out of line. They were arbitrary and capricious. They can easily be withdrawn. They should have been withdrawn, and we asked the court to order them to be withdrawn.
Isn't what you're saying is it's not the action, the underlying threatened action on the grants that you're challenging. What you're challenging is the sending of letters saying this appears to violate your grant assurances, and and the finality is that they're not willing, that the sending of those letters is final as to that opinion?
As to what?
The finality of the letters are harming us. We went,
We get that.
we went to
get that.
great efforts,
And
right?
no one up here is
Okay,
naive.
good.
We all get that. That's not the point. That's not the way we view finality normally. That's not,
But we put in the record the capital engineering report. We put in various letters that I sent to the multiple chief counsels. We put in evidence that was never addressed. It wasn't like.
Right, no, I get that. But that's going to arbitrariness.
Right.
And so, but it seems like what you're challenging is not a decision,
Right.
an actual underlying decision, whether the grant assurances are violated.
Right.
But rather a decision to take a different action that's having an effect on your client, which is an action expressing an opinion that the grant assurances might be violated. And then the finality of the refusal to retract that opinion, right? They're doing something in the world that has an effect on your client.
That's right.
For now, we're going to bracket the question of what the legal consequence is. But it's final in the sense of FAA action opining on something that has huge consequences for your client.
Yes,
So the final action the action you're objecting to is not a determination that the grant assurances have been violated,
that's right.
but
No,
an opinion
that's right.
about them.
and
We are
if they
challenging-
If we issued an order and they withdrew, they say, okay, we withdraw the emails. That is no assurance for your client that they will not act against you as they legitimately can. And if you said, but wait, they withdrew those emails, they would say, well, that's not the process for making the determination. We're now acting against you because we think there's a problem. You've gotten nothing.
These are letters, and it's like the SEC going to a company and says, if we're not telling you what to do, but if you roll out your what you're doing with this public offering, you're going to violate the SEC law. And if it was a total rogue agent at the SEC who had no business doing that, and we went to the SEC and say, you're screwing up our deal, please tell the world that the guy was a rogue agent and you're withdrawing his letters, and they refuse to do so, there would be a final order. That's what we have here.
And your position is the redress doesn't have to be guaranteed. It just has to remove an obstacle for your client that is, appreciable and
Right.
you're willing to be in that world where, yes, the city and FAA will continue to discuss this and potentially, have further interactions with you about it and make an open decision.
Right, because the
And maybe
city.
they will make the same decision, but it's your view that doesn't, A, defeat your standing, or B, render this non-final?
It's a final decision of the FAA. We have standing, and we're quite happy to have the relief be that the letters are withdrawn, because we know that there's no other basis for the city to refuse. But as long as they have the empty chair, they can point to the FAA, our hands are tied. We're just trying to take away that empty chair, which is unfairly prejudicing our client because of a rogue FAA agent who went colored outside the lines. And there has to be some way to deal with that when it's a real world impact. Now, if we had it.
Just one way of our.
Sure.
So if we really focus in on finality and what is the legal consequence, am I right that if the suggestion is that we might say this is a formal, straight-laced technical matter, there is no legal consequence unless and until FAA actually makes a decision that funding is revoked. And what you would say in response is, there's just no way in the real world we'll ever get to that.
That's right.
You can't make them start a Part 16.
Nope.
And the city in the real world is not going to do another thing with these threats out.
I couldn't have said that better.
Position.
That's exactly it. Could not have said it better.
And you're saying, but the legal consequence for you that you were pointing to is a business consequence. And you pointed to the situation in Security Point.
Right.
Other cases where, there are a number of cases where legal consequences are hurdles to a business that are raised or removed. What are in addition to Security Point, what are your?
Yeah, we cited a couple of those cases in the papers, Your Honor. I think one had to do with the water issue where they couldn't get, even though it was a third party involved, they couldn't get access to the water because of it. I do think it's a slippery slope, and there are certain situations where somebody could say, well, that's speculative. But here, we have a record where it was being approved, where coercion is in the record, and as a practical matter, there's nothing the city's going to do other than just twiddle their thumbs breadcrumbs and wait to see what happens in Washington, because rogue agent does something that is very threatening. It's not just, opinion, maybe you should look into it. They were very, very, very clear. This violates, this is not compatible with your airport. And if they had gone on the record and say why it wasn't compatible or why one of these ACs applies or doesn't apply, we wouldn't be here today, because frankly, we could probably have worked with that. But the idea they were just going to put their hand up and say, we're not going to allow it and we're not going to tell you why, is arbitrary and capricious. As a practical matter, we did everything we could. We didn't jump when the letters were issued. We didn't come right to court. We tried to give the FAA every opportunity to fix this, and that's what we're asking the court to help. Thank you.
Thank you. Morning, Ms. Lopez.
Morning. Sorry, it always takes me a second to get it to my height.
Take your time. You can proceed whenever you're ready.
May it please the court, Carolyn Lopez on behalf of the FAA. I want to start off where the court did in the colloquy opposing counsel with standing. I think, as per the discussion, National Wrestling and DNF Afonso are really the relevant cases. And I did just want to highlight one other piece of the record to talk about how strong the evidence, countervailing evidence here is that the city actually acted on multiple independent reasons. We don't actually have to speculate about what the city's reasons are. The city told us, this is at JA 197 to 198, particularly JA 198. And there the city laid out all of its rationales for not approving ModernWest. That included the city's own finding under its own municipal code that the project failed to mitigate adverse consequences to surrounding properties. Yes, it did mention the FAA, but it also mentioned Colorado. So it's just speculation from the other side that Colorado wasn't important to the city. The city said Colorado was important to it. And the city also incorporated all the rationales at the August 2024 public hearing. And those—
I think they would say all of these, there are a lot of different words here, but they're all just channeling this idea that the FAA has said there's a safety concern in the event of an accident. No one had thought of that until the FAA sent a letter. And so if we vacate those letters, there's no reason to think they're going to stick with these concerns.
No, Your Honor, because as per for a couple of reasons. One is sort of the legal framework that we've been discussing this morning, and one is the record before us. So the legal framework is when we're talking about these decisions made by the third party, it's a third party that's actually causing the injury, not directly the federal government. And the record suggests that there are multiple reasons. It's actually not the government's burden to show that there's no way that it's the FAA influencing, and it's petitioner's burden to show that, in fact, this was caused by this cause and not that cause. And we know that, for example, in DNF Afonso, which we talked about in our response brief, and to which they've, offered no rebuttal in their reply, or really today, the best they have is one city council member expressed earlier in these proceedings before that resolution was issued that she wasn't happy with FAA's letters. And that's simply not enough to carry their burden. And they certainly could have gone to the state to ask for clarification. And in fact, the record evidence that we have, again, at JA 198, suggests that there are these multiple independent reasons. And under National Wrestling and DNF Afonso, that's just not enough for them to carry their burden under state.
Do they have a right to get a response from the FAA?
These letters are between the city and the FAA because they have to
They have a right to get a response from the FAA as a developer in an area affected by some regulations that cover this. And they're good citizens out there, business people, and they know the FAA has a role to play. And so responsibly, they interact with the FAA. We want a response. Is there any issue here? To the degree that these are informal advisory letters between FAA and the regulated. I'm just asking, I'm speaking at the low level. Do they have a right to get, as citizens participating in this society, doing business, trying to follow the rules, do they have a right to go to the FAA and say, you apparently have a role in these things? We'd like an answer from you as to whether there's any problem. They have a right to do that? Judge Edwards, what I can tell you today is that to the degree that there is any such right, they did receive responses. And if I might just
go to the record to sort of walk through how those responses happened, so standing at the
Wait,
podium.
I'm not getting an answer to my question. You conceding they have a right to go to the government agency and to get an answer as a legitimately interested party to get an answer on a question that could be involved in this?
No, Your Honor, I am not conceding that they have some sort of formal right to a particular type of response
No, I
from the
didn't say that.
FAA.
Do they have a
when
right to
they-
seek? You're characterizing, I'm limiting it. Do they have a right to seek a response from the agency that is in play here? One of the agencies that's in play, City Council certainly is, the FAA certainly is. Do they have a right to say, and they got to have all these things, they have a right to say, well, we want to go to the FAA and make sure there's no issue here. We don't think there is. They have a right to do that?
They don't have the right to ask FAA to specifically approve or disapprove of particular development plans. But here, I do just, they ask the FAA
You
questions
don't want to answer my question.
and they,
No, I'm serious, because this is a silly case in a lot of respects, respectfully. And things went on. I'm speaking as an observer watching this. You say, how in devil does stuff like this go on? Why couldn't we just have answers given legitimately, as opposed to the government official having a role to play saying, we're not going to tell you anything, but if we have anything to say, it's bad, and we know that's going to hurt you, but it's too bad, and there's no way they can get redress?
so Your Honor, this is why I wanted to separate out for a moment whether there is a specific right of redress from what actually happened here. So what actually happened here, and this is evident in the record, is that FAA had multiple meetings with Petitioner, and at those meetings, so Petitioner had noticed both through their specific multiple emails and meetings with the FAA, and by attending those meetings that the public hearings that the city had. So if I could just take a step back, and I apologize, it's a bit of a wind up to walk through the record and all of those things, because I do understand Your Honor's concern, what is a developer supposed to do? And I don't think this is sort of a fringe case in which FAA just never spoke to the developer at all. And so I just don't think, the exact parameters of that need to be adjudicated for purposes of this case. So in terms of, we heard opposing counsel say today, listen, if they just told us the advisory circular was the standard, we would have known. Well, we did tell them that the advisory circular was the standard. So they talk about a letter they sent to FAA at JA 84. And the next page in the record is JA 85. And that's FAA's response. And FAA says in response that the city, quote, must comply with grant assurances and adhere to FAA advisory circular ACs regarding compatible land use.
See, that would be.
That's.
Right.
Oh, yes.
We've reviewed the record. There is never a time, is there, when the FAA says, the circular is very vague. It just says what the grant assurance says. Residential, high density, near airport, bad. They never said, this would be different if it was 500 feet that way, if you restructured the building in this way. It just over and over is a vague reference to a circular that is itself vague and says, apartment buildings near the runway are bad, and they're asking, where can we put it?
So,
And is there an answer that is instructive in any way on that?
Your Honor, respectfully, I disagree about the vagueness here. We're not talking about sort of a fringe case here. There's no question that this, for example, that this is high density residential living. These are 300 unit apartment buildings. And I think one of the pages that's the most specific, this is at addendum 8. This is the same advisory circular that FAA pointed them to. This is paragraph 2.3.1.3. And so they talk about this circular talks about ways to mitigate the hazards created by residential living. And it says,
Doug,
techniques.
addendum to the red brief?
Addendum to the red brief. It's addendum 8. And again, I just want to highlight that we included it in the addendum for the court's convenience for precisely these sorts of colloquies. But this is the same advisory circular that FAA pointed both Petitioner and the city to. So this is at addendum 8. It's paragraph 2.3.1.3. And it says techniques that can be used to minimize or mitigate the effects of such incompatible development include placement of residential structures on the outer edge of a parcel rather than directly underneath a runway's approach or departure pathway outside of RPZs being runway protection zones. And so if I might just take a step back to sort of describe what that means in technical terms, and of course the developer was represented by, very able counsel in these conversations with FAA. So these are not sort of new folks to these questions. Basically, when you think about approach and departure pathways from the airport, I'm oversimplifying this a little bit, but it's basically a triangle. And the runway protection zone is the part of the triangle that is the closest to the airport. And there you're not supposed to build anything. But the rest of the triangle, a little bit farther out, which is where ModernWest 1 and ModernWest 2 are located, you're not supposed to build high density residential. And we know that that's all in the advisory circular. And then just in terms of additional communications that got more specific between FAA and Petitioner. So for example, at JA 60, FAA said, given its location, high-density residential, so saying it's the location that's a problem, high-density residential will still be viewed as incompatible, even though it's only a portion of the development. At JA 47 through 49, this is sort of repeated a couple of different places, but this is one location. FAA discussed flight data, and recall that when looking at these images, this is just flight data from 3 days. It's not even a week or a month, and there are multiple flights that are flying directly over ModernWest 2. And so they really did give Petitioner, everything that they needed to know why FAA had concerns.
Can I shift gears so on finality, what can they do? If we issue an order saying you can't review this because there's not yet a concrete legal consequence in the sense of actually denying funding, how can they get to a reviewable order?
So
what should happen?
And this sort of segues a little bit back. This is where sort of, I think, standing and finality sort of merge a little bit here, which is that when we're talking about this field of where the injury occurs, not directly from the federal agency, but through some third-party actor, where the third-party actor has sort of multiple reasons why it says, and even if it had just said FAA raised this safety concern, said nothing about, it does say things about Colorado, it does say things about the public, but even if it just said, hey, we didn't realize that this was a problem, we've taken another look at it, it is a problem. We personally think that there's a safety issue. To the extent that they have any remedy, it's litigation against the city for, whatever loss of value to the land. Now, of course, if the city goes forward, then as this court recognized in Southwest Airlines, it's not sort of these initial, I wouldn't even call them pre-enforcement letters, just sort of flagging an issue and saying we may take enforcement action. It's what happens at the end. So either they convince the city that they're right and the city should go forward, and then there will be a final agency action through the Part 16 proceeding, or they fail to convince the city, and then because of standing jurisprudence, their argument is litigation against the city and not litigation against the FAA.
And the Part 16 is entirely, discretionary on the FAA when and whether to initiate, right? So
that's right.
If the city was really committed to this, do you think they would go ahead and approve and start building and just wait for the FAA to weigh in?
I think, one option would be the city could say, we are finally approving this building. We don't care what you said. We disagree that this is an incompatible land use. And then FAA would have the option of taking enforcement action at that point.
Has any, I think this actually is in the record, but are there any airport that has ever done that? Said, you have threatened to withdraw all our federal funding, but we're going to press ahead anyway and go through the litigation expense?
So, for example, Southwest Airlines is that case, right? It's not a land use compatibility case, but it's a grant assurance violation. And FAA says, we think you should stop doing it this way. And the airport sponsor says, no, we'd like to keep doing it this way. And then FAA takes Part 16 action. So
against Southwest Airlines?
Against the airport sponsor. That case was brought by Southwest Airlines saying, we have to be able to challenge the letters that were the advisory letters that were sent to the city or sent to the airport sponsor.
I'm just puzzled by, I thought that the record showed, and I'm just looking for it and not finding it. I thought the record showed clearly that the city had zoned this parcel for multiple uses, including high density residential. And I'm just trying to figure out why ModernWest was allowed to proceed as far as it was and given so many concrete assurances that it had cleared really significant regulatory hurdles, both with FAA and with the city, and that this could kick up as late as it did.
So I can't speak to what was happening between the city and ModernWest before FAA learned of this. FAA, as we discussed in our brief, first learned that not just there might be some, it was going to be mixed use. There might be some residential, which might mean one house, but that actually this was going to be, 300 unit apartment buildings when the city. So just to be clear, the airport manager is actually the city's own employee. And this happens sometimes with government. Different government actors have different ideas about whether something is a good idea or a bad idea. There's nothing pernicious about the airport the airport sponsor's employee saying, hey, this huge building might go up with lots of folks in it. FAA, do you have any concerns? So that's at JA 41. And at that point, FAA takes a look and tells the city, hey, we think there might be a problem here. And at JA 43 through 45, this is emails between FAA and the city. Apologize if I know I'm repeating things that your honors have already read, but FAA says, these aren't just letters going to this airport sponsor. It's not, some rogue letter just to you. We've sent similar letters to 4 other airports. And one reason we're really concerned is because at those 4 other airports, there were plane crashes in the zone of where, ModernWest 2 is being proposed to be built. That's a perfectly rational conversation to have between FAA and the city. And, I sure hope that my city, upon, getting notice of those types of dangers, would take a second look at things. And at that point, the city has multiple additional public hearings at which ModernWest was fully aware of those hearings. They attend those hearings, they attach those hearings to letters at the FAA. So this is, for example, the May 2024, or it might have been 2023 public hearing that opposing counsel was referencing. I apologize, my JA sites are to slightly different pages, but at those JA sites, it's the same hearing, JA 460. The city again notes, yes, this is new to us, but lots of other entities are getting these same types of letters. We're not being singled out. And I will just say it's not that surprising that this is the first time that the city receives something like that, because the land in question, if you look at the map, it's empty. So that it's not like there was previously a proposal to build.
See, the problem is the FAA, you disclaim, but the FAA wants to have it both ways. They don't want to be engaged, which these emails over the top and saying, this isn't final, we're being very self-righteous. On the other hand, they made it very clear this could create an unsafe and incompatible land. They're litigating the issue. The problem for the other side is, even though you're claiming we're not really weighing in here, the agency has weighed in. And it is suggested, here's what our determination would be. And in the last email, it says we're not backing down from our position. Well, if you're on the other side, that's a disposition, and the unfairness of it under agency law is we don't know if there's substantial evidence to justify the FAA's alleged concerns. There isn't. There is a behind-the-scenes connection from an individual who has a gripe in the local area, gets in touch with someone from the FAA, and then bad things start happening. That's not the way you litigate an issue before an agency. So this person has some gripe, goes to the FAA starts buying in, and they essentially are rendering dispositions on the merits and simultaneously disclaiming any. This is not final. We don't really have anything to say, incidentally, but we think what you're proposing violates all applicable laws.
No,
and
Your
we'll
Honor.
come after you.
So
I don't know how you leave something in that situation. Where are they supposed to get redress?
So
Where are they supposed to
they're
get?
supposed to get redressed by lobbying the city and saying, we think you should make
No,
it
from the
different zoning.
The FAA is a player. They assumed they were a player. They responded as if they were a player in pretty loud terms. I think a couple of times they sent emails without something preceding it to weigh in. They had been pumped up by someone in the local area. It's a very unfair process. They had gotten aroused and they weighed in, and they weighed in a way that was totally negative to the other side. The other side may deserve to lose, they may not. My concern is, did they get anything resembling process that we think is acceptable?
So, Your Honor, again, just to put a pin in the two thresholds the two threshold grounds where I think this petition should be dismissed. I just do want to be clear that I think the record does not reflect that set of circumstances. So again, one, FAA receives a letter from the airport manager. That's the person who is in charge of making sure the airport is maintained safely. And so we have a lot of based speculation from the other side that it's somehow improper for the airport sponsor to do that. But from FAA's perspective, that's actually exactly what's supposed to happen. A responsible airport manager, if they find out that there is going to be construction that might be a danger to folks on the ground because of airport operations, is supposed to tell the FAA. The other folks that FAA gets letters from are a pilots association. So it's the pilots association. This is at JA 88, the pilots association.
My question, I understand that can happen. What I'm asking is, you're adjudicating, my surmise from this record is you're adjudicating the rights of a party that has the right to be heard by a federal agency. You're effectively adjudicating their rights and then saying, go away.
No, Your Honor.
This is not final. Yes, we've damned you and we know it, and we're not back. The telling thing in that email, we're not backing down from our position. That's a negative position. You say that in the email, we are not backing down. That clearly an agency has to know that has consequences.
So
they issue that and simultaneously say, but we're not really doing anything here. Sure you are.
So just to be clear, Your Honor, at the point that that email happens, the city has already at JA 198, many months before, rejected the zoning approval. And so to sort of ask FAA to withdraw non-final agency action after the decision after the city has already made a decision, it's not surprising that FAA said, no, we're not going to do that. And then I understand, or I think I understand Your Honor's concern about sort of what is a developer supposed to do. And I think there are a couple ways to think about that. And this is sort of always the tricky part where we're talking about the agency action is to a directly regulated entity. That's the letters between FAA and the city. And somebody else who is not a directly regulated entity gets upset about what happens because of the agency's communications with the regulated entity. And this court, for example, in independent equipment says, if these types of agency actions, these letters back and forth to regulated entities are automatically final agency action, that is going to muzzle much needed, workaday communication between agencies tasked with safety missions and their regulated entities. This worked precisely the way it's supposed to. It raised to the city, which may have been under the misimpression that there were no safety concerns, that there could be safety concerns. If the city had gone ahead, then FAA would have had the option of taking enforcement action proceedings. And that's just the way this particular regulatory scheme is set up and consistent with this court's precedents in both the standing arena and the requirement that their final agency action petitioner just hasn't met their burden to show either of those things. And for the reasons that we lay out in the brief, we also think that there was more than sufficient agency explanation, particularly under this court's precedents under Taurus, where one looks not just at the face of the letters themselves, but the entire explanation. And indeed, the city in one of its city hearings makes this point. The city attorney says, this is at JA 119 through 120, the city attorney says, this isn't just from the letters themselves. This is also, they say that FAA's concerns were triggered because quote, its guidance document talks about density of residential development around an airport, and this development has been described as high density residential, and it is fairly concentrated, and goes on to say that the issue is that it poses a safety risk in the event of a crash, both obviously to the pilot and crew, but also to the people in the building. And so this really is a dialogue back and forth between an agency and a city. And then, as we know from JA 198, the city makes its own decision.
Is there any good reason that letters like this don't include much more tentative language?
Right.
This does not read. The first draft says this is in violation. You switch it to the FAA views. I'm actually not sure there's any difference between those, but it does not say at this preliminary juncture, based on our tentative review of the facts, we believe you may be in violation. And that would play very differently than this.
Taking a look back, of course, these are, technical folks. Could it have been worded differently? And would that have made my time at the podium a little shorter? Maybe. But what they did here is enough. So just to be clear.
There's actually a related question of why you didn't just withdraw the letters. If they have no legal consequence and you're going through all this problem and you're coming here and you believe that the city has now just independently agrees with you and the state independently agrees with you, it might have been a reasonable thing to do to withdraw the letters. And in doing so, say, just so you know, you are objecting to us expressing our view. We're going to not express our view. That obviously doesn't foreclose us from coming in later.
That's certainly an option that FAA
it's like a
had.
weird thing to do to come and defend them and say there's no legal consequence.
It's not odd in that the principle that is at issue here is FAA's ability to, rather than undergoing enforcement action when it may be too late, is to send advisory letters that say, we think there might be a problem. Can you take another look?
That is a very reasonable answer. They should definitely sound advisory and not like this.
So I do, I agree that there are other ways that the letter could have been worded, but I do want to highlight as well that the letters themselves specifically say that if you have any questions or concerns, please contact FAA. And so there's enough on the face of the letters to indicate that it's an ongoing dialogue. And the reason that we know it's an ongoing dialogue is because what FAA does is continue to have dialogue with the city in multiple conversations. And the city talks about that, and it's over several years. If there are no further questions, I would ask the court to dismiss the petition or otherwise affirm.
Thank you, Your Honors. I'll see you very quick, 2 minutes. The Southwest case was my case. Very different case. I think it's just important to put on the record. That was a situation in Dallas Love Field where Southwest had 18 gates. Delta wanted 2 of the gates. There's a big fight about it. The city filed their own lawsuit, washed their hands. And at some point, Southwest had to deal with some letters from the DOT that were problem letters. The difference is that by the time we filed that case, the DOT had convinced the FAA to file a Part 16. And sure enough, there was a Part 16. There was also federal district court litigation in that case. So there were ways for the parties to deal with whether or not Southwest needed to accommodate Delta's gate accommodation request. But in here we do not have an angle, and I think that's been very clear. I think when you're relying as defense counsel on the addendum, I think that says a lot. It would have been nice to have decisions that would have taken what was in the addendum, the advisory circulator, and put it in the facts of our case, but they didn't do that. As late as February 3rd, 2025, ModernWest, this is JA 575, writes a letter to Jesse Lyman. That's a new name. And he says, basically, we understand that, John Bauer, who wrote those 2 letters from 2024, is gone to another position, and you've taken his position, and that's fine. And we ask again, the letters do not state that the project is incompatible based on safety, noise, height, density, color, or any other factor, nor do they state the approval of the project would violate any FAA standard, regulation, or guideline. You don't cite a single FAA standard as to why this is violated. We would like you to do that so we know what it is we're dealing with here. And like everything else, that was ignored by the FAA. Finally, Your Honor, Again, and I think this, actually, I'm not even going to say it. I think what Judge Edwards said at the end kind of stole what I was going to say as to what happened here and how this came about. So we think that this was not the way Washington is supposed to work. We think we had a rogue agent who had probably the best intentions, but he went outside of the process. And therefore, because of that, our client got no process. And we would ask that these letters be withdrawn. And we don't understand, we agree, why the government that says if they have no legal consequence, why they will not withdraw those letters. Thank you for your time and attention.
Thank you. The case is submitted.
Case number 25-5256, Hesai Technology Co., Ltd. and Hesai Inc., appellants versus United States Department of Defense et al. Mr. Theis for the appellants and Ms. Michael for the appellees.
Good morning, and may it please the court. The primary question on appeal is whether the department acted contrary to law in finding a NASDAQ-listed automotive supplier a contributor to the Chinese defense industrial base without any evidence that it ever gave or supplied anything to the Chinese government or defense sector. Section 1260H required the department to find that Hesai contributes to the Chinese defense industrial base. All agree that the word contribute means to give or supply. Thus, the ordinary meaning of that phrase, which this court interprets without deference, means one who gives or supplies materials, services, or support to the Chinese defense industrial base. The department made no such finding, however, because no such evidence exists. Instead, the department argues that one can contribute merely by producing goods with substantial military application or benefit alone, even if nothing is ever given or supplied to the Chinese defense industrial base. That argument contradicts the statutory text. Congress targeted contributors, not every manufacturer of high-tech products. Under the department's interpretation, countless companies like Volvo, Continental, and Autoliv, all of which reside in the same locations in China and also work on autonomous vehicle technology, qualify as Chinese military companies too. Because the government does not contend that it can satisfy the give or supply standard that we propose, the court can vacate the listing decision on that ground alone. The government's failure to comply with Hesai's basic due process rights, we believe, only underscores that vacatur is the appropriate remedy. I'm happy to address the court's questions, but otherwise I can break down some of these arguments in a little more detail.
Can I direct you to one which you teed up, which is the government does not argue, I mean, it makes a lot of alternative arguments. It doesn't include one at the end that says that you contribute even under your own definition. And maybe you know where I'm going with this, but JA 90, this first national project, it says Hesai worked on a project for the NDRC that involved developing autonomous driving systems for the country's national defense and military industries, and so on. So why does that not on its face constitute working with the NDRC, one of the main military industrial planning organs in China, on something related to the quote defense and military industries?
Well, Your Honor, I'd like to look at that specific page of the record as well, because my understanding, Your Honor, is that the references, well, I have several responses to that, but
I appreciate they haven't argued it. It's the district court said this was at least evidence of some contribution.
Somewhat probatives. Yes, exactly. So to be clear, there are a couple of different things going on here. One of them is that the NDRC is the National Development and Reform Commission. They have a lot of obligations in China. The government alleges that one of those obligations involves defense. The project they're referring to, which I believe took place from 2017 to 2020, is not related to anything defense related. The government does not argue that it is. What they say is that we worked on this project back in 2017 to 2020, and that separately the NDRC calls for developing autonomous driving systems for the country's national defense. So to be very clear, the project in question was not a defense related project. The government has not alleged that that project was defense related. It's also old, as we said. The statute is supposed to be based on the latest information available, not the old information. It's waived. The government didn't actually argue this in their papers. I also think there's a Chenery issue too, Your Honor. As you pointed out, the district court said that this evidence is in the record. It's somewhat probative, but it's a Chenery issue because that's not what the agency relied on for the contributions to the defense industrial base. And in fact, it's a Chenery problem on steroids because they disclaimed that there was anything else that related to contribute to the defense industrial base other than the Defense One article. So again, I think at a bare minimum, this would require, I think, make it earn a remand for them to rely on this.
So with apologies in advance to you and my colleagues, I'm going to ask about another argument no one made.
Sure.
But the government did argue it below, and it's that this contribution part of the statute has no independent meaning. And the key to that concern, which at least makes it much harder than anyone has presented it, is that your argument is that would be surplusage, but your reading is adding words to the statute. You're reading it as though it says a military civil fusion contributor that contributes to the Chinese defense industrial base. That's not what it says. And when we have a defined term, you sort of just plop in the definitions into the defined term in the operative provision of the statute. And when you do that, this provision is entirely unintelligible.
I agree.
It says things like you reside in a military civil fusion and enterprise zone to the Chinese industrial base. So why shouldn't that be a concern? Because there is a sensible reading of this that is these A through G, at least, tell you what it means to contribute to the defense industrial base. And why isn't that, other than, waiver and all of that?
Well, we certainly have the waiver
The
problem.
adding words to the statute problem is very concerning to me.
I take your concern very seriously, Your Honor. I mean, first of all, again, the waiver problem, party presentation, we would have briefed this case differently if they had argued it differently. Second of all, I agree with you. It makes a hash of the statute to try to say to the defense industrial base, plop that word in. So the idea then is what's the best reading of this provision? And I think for a couple of reasons. Number one, the surplusage problem, which you've identified. But I think the other key reason is that many of those sub-factors sort of imply a contribution to the defense industrial base already. For example, a license, obtaining a license for defense production services.
Exactly, but that would be the main thing that cuts against you.
Agreed, except for there are at least two of those provisions that do not imply at all a defense connection. One of them is residing in a military civil fusion zone. I think that's key. Residing in military civil fusion zone, I think the record shows that in the Jiading zone alone, which is in suburban Shanghai, there's over 2,000 companies, including a number of Fortune 500 companies there. It's a industrial area of town. There's a lot of car manufacturers there. So there's a lot of that's why we're talking about Volvo and Continental and Autoliv, VW as well. I think Amazon Web Services is there. So if the reading of the statute is the one that you're proposing, which the government has not raised, but if it is, then necessarily all of those companies are military civil fusion contributors as well. And we don't think that's a tenable reading. We don't think that's what Congress was
What's the second
going for.
Sort of unbounded one? Is it H or did you have another one?
I think it's A, Your Honor. I mean, I think there's at least those two. I think you can make an argument for others, although many of them have the word defense in them, which again, I think sort of implies that Congress was focusing more on the defense industrial base. But A is just, not A, B. Entities affiliated with the Chinese Ministry of Industry and Information Technology. The Ministry of Industry and Information Technology, the MIIT, is, based on the record, the chief industrial and technology regulator of China. From what I understand, it's a combination of Department of Commerce, our Department of Commerce, the SBA, Department of Agriculture, I believe. It's economic regulation. So it regulates high-tech industries, but it also regulates, fishing poles and agriculture and consumer technology. So again, if it's simply, and the government takes a position, in fact, I think the statute says affiliated with means in close formal or informal association. So I think if you don't have the defense industrial base gloss, suddenly there are hundreds of thousands, if not millions of companies that could be swept in under that. So
I think the difficulty is that this statute is trying to deal with is this military civil fusion. I mean, in a way, your answers are saying it can be just civil, it could be just military, or maybe more clearly military. And Congress here was reacting to the approach that is, very distinctively followed and increasingly followed in China of not making that kind of distinction and having this really ample civil developments and military developments. And I think it's precisely so that to the extent that it is in the interests of the Chinese government to obscure the connection, that doesn't prevent Congress from paying attention to industries like your clients that may have implications. I mean, what is the, in your view, the purpose of this Section 1260H list? What is your understanding of what Congress was trying to do in enacting this?
I mean, I don't strongly disagree with the way you're describing it, Your Honor. They were trying to target companies that, though they have a commercial purpose, are contributing to the Chinese military and the Chinese defense sector more broadly. In fact, that was the definition that the Department of Defense gave below in its summary judgment briefing. It said the straightforward reading of military civil fusion contributor to the defense industrial base, and I'm quoting here, demands that an entity must be a contributor to the Chinese military that also has civil or commercial purposes. That was in ECF number 23, their summary judgment brief. So I don't disagree with that, but I do think that Congress did this. It didn't just say, because of the nature of civil military fusion, all high-tech companies in China should be added to a list, because civil military fusion means that everything high-tech is going to be helping the military. They did it in a particular way. They said, here's what a military civil fusion contributor is. There's these 8 categories. So these are the ones that deserve heightened scrutiny. And then it said, which of these companies that fit, reside in these particular places, have these particular license, receive particular funding, which of these are actually contributing to the Chinese military, whether that's directly or indirectly, whether that is knowingly or unknowingly, whether it is through a formal contract or through some other means. But I do think it's very critical to give some teeth to the contributes to, as in giving or supplying, because otherwise it's just a list of technology companies. And in fact, it's not just a list of technology companies, it's a partial list of technology companies. They're adding my client, but they're not adding other companies that are in the exact same situation.
But given both the U.S. Congress's interest and the Chinese government's interest, why does it matter whether your client's LiDAR is commercial grade rather than military grade? I thought the record reflected that the Chinese military found even commercial grade LiDAR quite useful for a variety of functions.
Right. Well, if we're talking about the record, it's the Defense One article, I think, was what the Defense Department belatedly relied on. Obviously, that was not mentioned in the decision itself. It was only added during summary judgment briefing. But yes, that was the case. But I think we'd be in a different situation, Your Honor, if there was evidence of Hesai's technology actually being used in any way by the Chinese military. If our LiDAR was being found in Chinese military vehicles, if even our type of technology was, the actual specific technology we developed, there's some record of that, maybe we'd be in a different situation. But that's not what's going on here. They just say anyone who creates a technology with substantial military application or benefit deserves to be on this list. It's contributing. And again, I think that erases the word contribute from that definition. You're not giving or supplying anything.
The
in that
dividing line
circumstance.
for you is if Hesai is there with very advanced, research technology center, it's working on this technology that the Chinese government also happens to use, but DoD needs evidence that it is being supplied directly or indirectly.
That's
Hesai
right.
specific products to someone in the Chinese government.
Either Hesai specific, yeah. I mean, I think, yes, that is our main position. There just has to be some giving or supplying of our technology or products or services. I mean, that's what contribute means. Again, on page 40 of the government's brief, it says the ordinary meaning of contribute means to give or supply. And so if our products are being given or supplied, we're not asking for an insurmountable barrier. We're not asking for the government to prove that we knew we were trying to help the Chinese government, that we knew even that we were necessarily contributing to it. But it has to actually be given or supplied for contribute to make any sense.
Another angle someone might
Excuse me.
push back is that we're not arguing actually about the meaning of contribute. We're arguing about what the defense industrial base is, right? So you could be, if the defense industrial base is something which I concede is very broad, like the productive capacity of China's industrial base, which could be called upon by the Chinese defense. And there is this theory that Judge Pillard previewed that basically that is the Chinese government strategy. Powerful technology, at some point it's there, it's available to be used for defense purposes. What's wrong about that?
Well, again, Your Honor,
I mean, it would be very broad, but it is a coherent, it focuses the dispute on what defense industrial base means.
I think there's a few issues with it. Number one, again, exceedingly broad because it would just sweep in, I think, undisputedly companies like Volvo and Continental and Autoliv who satisfy all the same criteria. So I think that's one problem with doing it that way. Another one is that the definition that we proposed is from the Congressional Research Service, and it says the organization's facilities and resources that supply. They're talking about the US base, but I'm subbing in the Chinese government with materials, products, and services for defense purposes. If Congress had wanted to create a list, I keep going back to this, I'm sorry, but they wanted to create a list of Chinese technology companies, there was a way to do it. But that's not what they did. They asked for military civil fusion contributors to the defense industrial base. And if you define it as just anyone who makes high-tech products, then there should be tens of thousands, hundreds of thousands of companies on the list. That's just implausible interpretation, we think, of what Congress was really going after.
So in terms of contribute, and I mean, it's interesting that this case comes to us under, I guess it's E, the presence of your client's facilities in the military civil fusion enterprise zone.
Mm-hmm.
And in terms of how does that contribute to the military civil industrial base of China, the district court arrived at a definition of those zones as a section of territory established by the Chinese government for the purpose of advancing its policy of military civil fusion. So again, I agree, it's pretty nebulous, but the core idea is that these zones, unlike the city of Shanghai, the point of these enterprise zones is that they have distinct regulatory structures, distinct commercial advantages. And if the Chinese government has defined a zone as something that is advancing its military civil fusion policy, then being there, why is it not a contribution to that military civil industrial base?
Well, a few reasons, Your Honor. I mean, I think, as you say, it's quite nebulous. There's not a list of Chinese military civil fusion enterprise zones that the department has relied on. Rather, it has identified industrial zones that someone in the Xiaodong zone, a regional official, and maybe I'm getting it backwards, the Chongqing region in the Xiaodong, it's a industry alliance, which I take to be like a chamber of commerce or something, has touted as advancing military civil fusion. Jiading is a little bit different because it seems like there's also a military industrial park within Jiading region. Within the greater region, there's a smaller part that is specifically focused on the military, but we're not in that part. And they don't suggest that we are. So I think, number one, it's quite nebulous. It's not, I would agree with you, it would be different if there were just very established zones, but instead it is very nebulous. It's a strange term. I don't really know what it means. I don't know how you even show that you've established a zone as a military civil fusion zone when, again, you don't have the central government coming down and saying this. You have regional people or chambers of commerce type, industry alliances. I think it's one thing. The second problem, again, we've talked about it several times, a lot of other companies in those zones. There's 2,000 companies, 500, Fortune 500 companies. I assume there's coffee shops and laundromats as well. Are they military civil fusion contributors? I don't know. You have, and I think it's really crucial too, Your Honor, that the government takes the position. I think the district court recognizes this as well. But this is brief 32, note 4. The government says that this factor rests on residence in the zone and nothing more. So if that is the case, if you're going to accept that definition, and again, I'm not quite sure how better to read reside. Unfortunately, I wish I had some argument for you on that. Then I think it's critical that the word contribution to the defense industrial base gets some teeth, because otherwise you are sweeping in potentially thousands of companies, including Fortune 500 companies and others. So, I think it all ultimately comes back. I think there are some serious problems with the government's definition of this zone and the substantial evidence that they relied on. But ultimately, it seems to me that if you actually take the contribution to the defense industrial base seriously, then that's less of a problem, because those are just companies to be sort of identified as potential military civil fusion contributors, and then you're having or potential Chinese military companies, and then you are using the defense industrial base to actually connect those dots.
Switching gears a little bit, I take it Hesai does not have a concrete interest in contracting with the U.S. Department of Defense.
We do not contract with the Department of Defense.
Or have a concrete or imminent interest in
that. There's no imminent interest in doing so.
And what about pursuing grants, loans, or contracts under the CHIPS Act?
It's not in the record, Your Honor. I don't know. I think if it was available to them, then perhaps they would. But it's not in the record.
So the liberty interest in support of the due process claim is what?
Well, Your Honor, the way we read this court's cases, including the Taylor case, is that there's essentially two requirements: that you have a stigmatizing action by the government and that you have a change in status under law. I think that was also recognized in the NCRI case. It said there was a stigmatizing designation or listing plus the deprivation of a right under state law. I think we have both of those here. We have the stigmatization, that's not in dispute. I'm happy to go into that if you'd like, but the question is there a change in status under state law? And what a lot of cases have said, in fact, a quintessential right under state law is the ability to, or under federal law, is to bid for government contracts. So I don't think the only response the government has to that, as I understand, is that it's not ripe because we're not currently planning to do it. But I don't think that that's the test. I think the due process claim is currently ripe. We have a change in status under law and stigmatization.
It's not just ripeness. It's just that it's nonsensical to say that we have a constitution that protects liberty in doing something we've never expressed an interest in doing.
Well, we have a the constitutional right that triggers due process. The constitutional right, as far as I understand it, in the stigma plus cases, is the right not to be stigmatized by your government. It's in the Paul v. Davis case, which is discussing the Constantino. It says that it was the alteration of Constantino's legal status, which, combined with the injury resulting from the defamation, justified the invocation of procedural safeguards. And I think in the Constantino case itself, as we point out, the question there, the deprivation was the inability to buy liquor in liquor stores. But the court didn't say, are you presently intending to buy liquor? Because if not, then you don't have a claim. It said, no, you've been stigmatized and you've had a change in status, and that's enough to invoke this court's, or the Supreme Court's in that case, but this court's due process precedents. And I think it's very, very similar to the NCRI and PMOI cases, where that was a foreign terrorist organization. The court several times held that when there's a stigmatizing action like that, plus a deprivation or a change in status under law, then that's what triggers these protections. And I just don't think that, it seems to me quite on point in this circumstance. I would also point out there's one other thing. It's not in the briefs, but there's actually at least one state, Utah, actually prohibits us from purchasing property because it basically says that any restricted parties, including Section 1260H companies, are not allowed to purchase property in Utah. And I feel like that's another. I apologize, it's not in the briefs, but that's Utah Code Section 63L-13-101 and 201. So I think that's another.
One last big picture question on the statutory interpretation. And we don't have a whole lot to go on in terms of what Congress was trying to accomplish.
Fair.
But obviously one of the perhaps the best argument on your side is that if the government and district court are right, this is incredibly broad. And and one just high level answer to that I think we would have to embrace if we were going to rule for the government is, yeah, it's extremely broad. And what Congress was doing here was conferring a large amount of discretion on DOD as to who to put on this list. And this is not a criminal statute. It certainly has some tangible consequences, but it's also not like commerce putting you on a sanctions list and not letting you import your product. So maybe Congress did really want to cast this extremely broad net and say, so the answer to if you're making beans in this part of China, then maybe you are a U.S. military company. Can you give us anything to work with to understand why that would be wrong?
Well, yeah, a few things, Your Honor. I mean, I think first of all, if that's the case, then that makes the due process concerns even more salient. I think that would give us, it makes it important that we get some process. But I think separately, and second of all, I think then opens the government up to the sort of ACA international line of arbitrariness. If that is the case, if it's truly as broad as they say it is, then there should be thousands or tens of thousands of companies on this list, including other LiDAR manufacturers. There are other LiDAR manufacturers in China who are not on this list as well. So I think if they're going to take such a broad position, then they actually need to put their money where their mouth is and add a whole bunch of companies to this. And that would actually make it less stigmatizing because then it would just be a list of Chinese technology companies. But that's not what they're doing. They're focusing on particular companies. And that's what the ACA international case said. It said essentially a standard is arbitrary when it embraces one potential application but leaves out another seemingly similar one. They're just picking and choosing among all of these companies that meet their own standards and saying that some are Chinese military companies and some are not. And that just seems incorrect. It seems either their standard is wrong or they're acting arbitrarily. But either way, I think vacatur should be the right result.
If we were to agree with you, and I'm not saying that we have any opinion formed on that, and we found that there was a lack of procedural due process, could we leave the designations in place and allow a remand? I mean, we did that in NCRI and PMOI.
Yeah,
and this is a less intense kind of a list, but.
Well, it is less intense now, Your Honor, but every year the list has changed, the consequences changed. There's been, last year it was denying CHIPS Act funding. 2 years ago, it was denying the ability to put our products in any products that get sold to DoD, not just direct sales, but indirect sales. So every year there's more significant, there's legislation floating to ban companies on the 1260H list from NASDAQ and other public listing things. I don't know if it's going anywhere, but the point is that threat is out there. So I don't think it's
the consequences in those other cases for the listed entities were much more severe, and we remanded leaving them on the list.
Correct, Your Honor. So obviously this court has the discretion to do so. I would urge the court to actually vacate for a few reasons, though. Number one, this case has bounced back and forth between the agency and the district court several times. We've been listed, we've been delisted, and then relisted again. We think the government cut some corners. Again, not to personalize it or anything, but just there were some issues with a failure to provide evidence. Changing their mind at the 11th hour, having us rebrief everything. We just think this is even after taking that second chance, they still couldn't get all the evidence in the record. So I think the combination of that kind of procedural history plus the lack of due process here really does counsel in favor of a vacatur. Remember that the government has an annual listing process in which they can add companies once a year. And so if we're vacated from the list, the government will have an opportunity either later this year or early next year to re-add us to the list if it feels like it has better information. But in the meantime, we just think that justice requires
Why would we be
vacater.
inclined to vacate when you started out by indicating it's true, we don't know that we would ever be caught in this net by doing what is prohibited, governing contracts or the like. You have no current intention. And there's no evidence. I mean, that's precise. It seems to me that's precisely the kind of case where we'd follow what our courts have done in the past. It's not like you're being hurt in any way that you could be hurt if the statute's invoked, because you're not being denied anything because you're not looking for it.
Well, Your Honor, we are being harmed in the same way that I think the stigma plus cases recognize. The Constantino case.
I mean, when we have cases on the books, I understand that point. We don't want to be stigmatized, except we have case law that says, no, we don't vacate in this situation. We want to get it right.
I understand that the ordinary course is to vacate. I just urge you to vacate in this circumstance. This is, we've been placed on the list because we make a certain type of technology, not because of a specific concern about our company and what it does, what it has done. So I just think this is a circumstance where obviously this court has discretion to do what it will, but we're being called a Chinese military company that has harmed our stock price, disrupted a factory we were going to build in the United States, canceled contracts. It's been very harmful to the company. There's a reason why we've been fighting this so hard for several years now. It's because the stigma itself, not the idea that we need to get a Defense Department contract, is very painful to our business. And if this court were to say, sorry, you didn't have either due process or, more importantly, you never showed a contribution to the defense industrial base, that would go a long way to restoring our credibility in the world, in the market. And if the government decides to relist us, then we'll fight that one as well.
Can I ask, just on that note, there is a statutory requirement to publish this list. Have you given, this is maybe an unfair question, but have you given any thought at this point to what happens if a new designation is published next week or next month and they rely on different grounds? Does this become moot? How do we, if they rely on the same grounds, we would say that's, capable of repetition, evading review. But it does seem like something that could disrupt our ability to review this.
Yeah, no, it's a totally fair question, Your Honor. I have thought about it. First of all, there has not been a new decision. There was actually a decision briefly published and then retracted the same day.
When was that?
On February 13th. Unclear why. The department has not publicly revealed why it published. And
that does make this sound maybe more imminent of an issue, but we can deal with it when it
was publicly. So yeah, of course, I would like the opportunity to brief anything if that were to happen, but I don't think it would make it moot regardless. I mean, number one, what the government said in this brief on page 7, note 3, that the amendments to 1260H did not affect the text of the definition of a military civil fusion contributor relevant to this appeal. So we don't think the fact that there have been amendments to the statute, or the fact that there's necessarily the fact that will be a new listing necessarily affects anything. And even if it were on different grounds, the 1260H still requires a contribution to the defense industrial base. I think there's a number of cases from the circuit. I'll point you to Capital Power Corporation v. FERC, which is a 2025 case, 156 F4th 644, and it said a case is not moot when a litigant's injury in fact stems from two individually sufficient causes, and a reversal on one will help you.
The contribution issue carries through. So okay,
that's right. So it certainly would make it moot. But obviously, if the court had any concerns about that, we'd love the opportunity to brief it if and when that happens. Thank you very much.
Good morning, Your Honors, and may it please the court, Urja Mithil for the government. I'd like to take a step back and briefly explain a couple of the baseline findings underlying the agency's decision that illustrate why Hesai falls in the heartland of Section 1260H, and then maybe I'll turn to a couple of the statutory points that Judge Garcia and Judge Pillard raised with respect to the word contributor in the statute. Hesai is a company that makes LiDAR, a technology that uses lasers to create a 3D representation of an object's surroundings. It's used in self-driving navigation systems, for surveillance, for targeting systems, and for situational awareness. Hesai doesn't dispute the PLA's interest in the LiDAR that Judge Pillard raised earlier. It doesn't dispute that it's setting up major R&D facilities in at least 2 of China's military civil fusion enterprise zones, and that these are areas where government authorities have publicly declared a strategy of supporting private technological development for industrial and military advancement. These are the primary bases for the part of the decision that's on appeal. As to the questions that we were talking about earlier about the statute's use of the word contributor, I think your honors are correct that A through G in the statute tell you what it means to contribute, that Congress made a judgment about what counts as a contribution when it defined a military civil fusion contributor. I think this came up briefly at the last argument involving the statute, and we've addressed it briefly the district court addressed it as in a slightly different version of the argument, where there was a discussion about whether separate findings were necessary for the military civil fusion contributor part of the statute and to the defense industrial base part of the statute. And we agree that there is first a determination that this company is a military civil fusion contributor, and then there's a determination about whether that contribution is to the Chinese defense industrial base, which is, I think, what your honors were talking about earlier. That contribution and that prong of the statute, there's a section of the agency's decision that addresses that. And we think that that determination, which again, Hesai doesn't really dispute, suffices to show that Hesai's development of this LiDAR technology contributes to the defense industrial base. And I think Judge Garcia made the very good point earlier that the question here is whether there's a contribution to the defense industrial base, and you provided a very nice definition of that, not to the military per se, and that's a broader term. There's a definition of defense industrial base in the brief that the district court accepted, that Hesai didn't dispute. The definition you provided works just as well. It's a broader term about capabilities and the development of those capabilities that could be marshaled later by the military industrial complex.
But the bottom line of that position is that any company working on technology that the Chinese defense apparatus might be interested in someday, even if that company does everything they can to not share their technology with the Chinese government, is eligible for the list, right?
It would depend on that. I think what Your Honor is saying goes to whether the contribution is to the Chinese defense industrial base, and that is a broad term, as Your Honor has described. It wouldn't suffice to place the company on the list, because to be on the list, you would have to meet one of the 8 definitions of being a military civil fusion contributor,
you're in a
or be
zone.
Otherwise.
You're in one of these zones.
Sure.
Which is being interpreted fairly broadly itself. And I just think you need to be transparent about what that, if you're in this part of China and you're working on any technology that the Chinese government might be interested in someday, you can be on the list. That's the bottom line, right?
That's the interpretation of those statutory words for sure. Those are broad words that Congress wrote into the statute. Congress determined that residing in the zone is sufficient to render you a military civil fusion contributor, and that's because of the unique characteristics of these zones. And we've outlined those in our brief. These zones are zones where public authorities have adopted policies of furthering China's military civil fusion strategy. There is record evidence of that. That's relevant. These are not just arbitrary geographic regions. And so
what about, I understand that, and I read your brief to explain that, and I was reading that definition to your friend on the other side, but what about his point? And I think your answer has to be yes, that if the US government wanted to put on this same list the non-technology companies in the zone, that it could do that, and that it hasn't distinguished between other technology companies in the zone and Hesai for purposes of why Hesai is on the list and the other companies aren't, or other LiDAR companies in the United States. It just feels like there's a real problem of unbounded discretion for the government in using this list.
So a few responses, Your Honor. First is just sort of, I think, getting at both, which Garcia was getting at earlier and what your question is getting at. The statute does vest some measure of discretion in the secretary to make these determinations. And I think we're not backing away from that section. Subsection A says the Secretary of Defense shall identify each entity the secretary determines based on the most recent information available is operating directly or indirectly in the United States or any of its territories and possessions that is a Chinese military company. So there is discretion there in the phrase each entity the secretary determines based on the record that the agency gathers and develops and then presents to this court. So that discretion is there in the statute. Then if you look at when the agency looks at companies like Hesai or other companies, it determines whether those companies meet the definition of a Chinese military company, which is fairly articulated in the statute. There are 8 various definitions of military civil fusion contributor. They're all a mouthful to say out loud. The phrase military civil fusion contributor itself is. Those companies also have to be operating directly or indirectly in the United States or any of its territories and possessions. That's a limitation in subsection A. And then I think the sort of last sort of atmospheric point here is that in the exercise of the secretary's discretion, you see that it's not unbounded, and you see the sort of ways in which the secretary exercises that discretion in this record itself. The agency's decision has 4 bases on which this company was determined to be a military civil fusion contributor. You don't need to look at all of those other pieces of other determinations to uphold the district court's decision, but that ample evidence here of Hesai's ties to the PLA or to the Chinese government sort of confirm that discretion was properly exercised in this case, that Hesai, as a company that's making this LiDAR technology and is residing in this zone, is precisely the kind of company that Congress had in mind when it asked the agency to go out and make these determinations and then prepare a report and a list for Congress. And that the breadth of the phrase.
Sorry, please finish.
I was just going to say the breadth of the resides in a military civil fusion enterprise zone definition is I would say like a feature of the statute that Congress wrote into it. Congress knew that these are the ordinary meaning of these words. It didn't choose to define them in any more narrow a way. It reflects the breadth of Congress's concern with the sort of many ways in which China carries out its military civil fusion strategy, and gave the agency the discretion to make those determinations based on what's going on in China, what kinds of companies are operating, how they're affiliating with the PLA and the Chinese government.
Sounds like you're suggesting that contributor is an unbounded notion because discretion is given to the secretary. I mean, discretion can be very limited, or it can be bounded, or it can be unbounded. And if what my colleague suggested is true, as long as you're in the zone, you're a contributor, because someday maybe you will be a contributor. That seems a strange definition, no?
I don't think, Your Honor, that it's.
And then you're, as I'm hearing you, you're saying, but he has the discretion to make that decision.
I'm saying, Your Honor, the agency has the discretion to determine what companies qualify as Chinese military companies.
No, but that's begging the question. That is the question. That's not how we bound the discretion. We have to have some factors that the secretary would look at.
That's right, Your Honor. But for the definition at issue in this appeal, the residing in a military civil fusion enterprise zone is what Congress determined qualifies a company as a military civil fusion contributor. Congress made a judgment that that is a contribution, and for good reason. I mean, these kinds of zones, as the record shows, and the department took care to assemble that evidence of how these zones are advancing and publicly announcing that they're advancing this military civil fusion strategy. So it's not as if there was sort of a cherry picking off of a list of companies in this zone. There was record evidence assembled of what this company does, of what its technology does, of what the PLA's interest in this technology is, of its presence in these zones, that it chose these zones to site its own facilities in, and then that these zones have announced this partnership with both Hesai and any other companies. And so it is true that Congress wrote the statute in a broad form. I'm not backing away from that. I'm just saying that the way that the secretary then exercised that discretion shows that it's not unbounded, that it did so appropriately in this case.
I'm hearing you to say that it's not unbounded because the secretary is limited to those who are in the zone. And there, as the other side argues, but there are many, many, many companies in the zone.
There are many companies in the zone, but
And I'm hearing you to say, as long as you're in the zone, there can be no abuse of discretion.
that's not what I'm saying, Your Honor. What I'm saying,
Well, then I really do need to hear your answer to my colleague's initial question about how, if we do, how we size this down in reviewing what's been done, because that's exactly the position. He can tell me if I misheard him. That's how he was posing it. Essentially, you're in the zone, but no threat whatsoever now. No one can see any threat. You're not doing anything. You make ice cream, that's all, but you're in the zone. And someday that ice cream may be a problem, and therefore, because you're in the zone, you can be captured. Yes or no?
no, Your Honor, because in that case, there are two, I think, identified two other features of the statute that limit. It's not just being in the zone. One, you have to be operating directly or indirectly in the United States or any of its territories or possessions. So some of the sort of other hypotheticals would fall outside. And the second is that you have to, that contribution has to be to the Chinese defense industrial base. The statute, it's not just being a contributor. There are 8 definitions for being a contributor that are set forth in the statute, but that contribution then has to be to the Chinese defense industrial base. And I think Judge Garcia pointed out earlier that there's other evidence in the record the district court credited that we reference on pages 37 and 38 of our brief, like these 2 national projects that Hesai engaged in partnership with arms of the Chinese military industrial planning apparatus.
But
And that there are those.
Did the decision rest on those? I thought that Mr. Tice said, no, that's has a Chenery problem. That's not what was relied on, that only the Defense One article is really being relied on.
The agency's decision does not list those 2 projects under the subheading of contributions to the Chinese defense industrial base. And this court, just like the district court, could uphold the agency's designation on the basis of only the statements that are underneath the subheading contributions to the Chinese defense industrial base. This finding that Hesai doesn't dispute that PLA uses LiDAR in its development, the Defense One article, the contents of which Hesai doesn't dispute, that's all fine. I'm pointing to these other pieces of the evidence in the record as evidence of how of other ties to the Chinese defense industrial base. I think it would be proper for this court to look at those. I don't think it would be a Chenery problem because all of this evidence is overlapping, because a contribution to the Chinese defense industrial base, all these other pieces of evidence are also aspects of those contributions. And sort of, I think we talked about this again at the last argument, but the first part of the statute, military civil fusion contributor, is tied sort of ineluctably to the second part of the statute, to the Chinese defense industrial base. And so it's a contribution to the Chinese defense industrial base. And so all of these pieces of evidence that go to whether Hesai is a military civil fusion contributor are relevant and fine for this court to look at. You don't need to in this case. You have enough evidence in sort of even just looking at the rest, but the district court looked at it properly, we think.
Can I, just to go back to Judge Edwards' question, if your statutory interpretation is right, then it does run into this argument from the plaintiff that there might be 100 similar technology companies in the same zone, and you've listed this one. And we do have cases that say you can, regulate step by step, but at some point it becomes apparent that the concern would be that the department is exercising its discretion based on factors no one knows about and aren't in the statute. Why isn't that a concern? Is it, you could give remarkably broad discretion and then say, you shall consider the following 3 or 4 factors, but the statute just says it doesn't have anything like that to guide the department's discretion.
So I think 2 points, Your Honor. One is, with respect, I think the statute gives quite a lot of guidance to the department about how military civil fusion contributors defined and so on.
They operate in the U.S. They are in some very big area of China, and they work on technology that might benefit the military. And let's just say that they're right, that includes Volvo, 10 other car companies, and 30 other technology companies, including 5 other LiDAR companies that aren't on the list. And nobody can tell why this company is on the list and those aren't.
So I think if there were hypothetically companies that you could assemble a record that would satisfy all the same elements. It still wouldn't be an arbitrary and capricious claim here. I don't think, one, sort of as an atmospheric point, there's been any evidence of the department exercising its discretion in bad faith, which is what this argument sort of sounds like. Two, I think all of the sorts of arbitrary and capricious cases and claims that plaintiff points to here are all cases where an agency made one decision at time A and made another decision at time B, and then the plaintiff at time B went back and said, look, the agency's reasoning, the agency hasn't explained properly and provided adequate reasoning for its departure from time A to time B as between these two companies, similarly situated companies. But there's no case that plaintiff has pointed to that says an agency has to explain its decision, especially when it's proceeding case by case, as it's allowed to do under this court's precedents and under Bell Aerospace and so on, that the agency has to then compare this company against all other possible companies that might fall within this definition. And I think that's appropriate. That's what it means to allow an agency to proceed case by case, both in expounding the meaning of a statute as it applies it and in administering the statute. And I think sort of one other atmospheric point is it wouldn't necessarily make sense, nor did Congress sort of direct the agency to disclose every company it is assessing and determining which companies fall on this list and which fall outside of it.
It would at least be discernible to us why, or that we should be able to surmise why this company and not all those others. And it's there are cases that say if there's one company is listed and 100 other apparently similar aren't, that's arbitrary and capricious.
I think it should be, I appreciate that it should be discernible. And I think the agency decision here sort of makes it discernible. And that's why I was pointing, notwithstanding the breadth, which I'm not contesting, of these statutory provisions, to all of the other evidence in the record about their ties to the Chinese government and the PLA. That I think explains sort of in a common sense way, to the extent there are concerns about these other common sense companies that, again, we don't have a record before us, so I don't want to opine on what the agency did or didn't determine with respect to the companies that aren't before this court. But to the extent there's concern about, what happened here and why this company, I think this agency decision is fairly detailed. The administrative record is fairly detailed about why this company, why LIDAR raised particular concerns, why this company's ties to these zones and to the government raised concerns. And that's sort of why I was pointing to the two national projects that Judge Garcia raised, not to say you need to rely on them or to say like there's not enough evidence in the record already, but to say, look, there is that evidence here that sort of dispels any sort of, again, concerns of bad faith.
So here's a question I have. It was striking to me that, and I know the statute lists whatever it is, A through G, as each an independent way of being a Chinese military company. But given that there were 4 different grounds given in the DOD decision here, why wouldn't the defense be and the district court decision be written as, well, at least where all these 4, there's some evidence, all these 4 together, we're satisfied. And we're not going to say whether just being in the zone suffices. It seems like it's putting us in a position to, in a case in which, as you point out, there may be a lot more evidence of a range of different kinds of ties and contributions to Chinese defense capability. It's putting us in a position of taking a relatively nebulous one and saying that alone legally suffices. Like, could we affirm by rolling together the 4 bases and saying, we're not going to opine whether the one that the district court relied on suffices, but we think here it does?
So I think just two quick points. One on whether this was sort of nebulous. I think, in fact, the text of subsection E is fairly clear, and that's why Hesai isn't disputing that it resides in the zone. It's broad, and I can understand Your Honor's concern with that. But I think that's why the district court went off only on that. It didn't need to reach the other grounds, and we've asked this court to affirm on that ground because we also think it's fairly straightforward. I think it would be we would have no objection to this court saying, look, there's all this other evidence in the record of Hesai meeting the statutory definition for a military civil fusion contributor. And as a result, it meets the definition under any of the other terms. I think we wouldn't object to that. We explained, I think I was explaining earlier and have explained previously that it's not, we don't think it would be error for this court to look at all of the evidence in the agency's decision because these statutory provisions are overlapping, because the fundamental inquiry of whether the agency properly deemed this company a Chinese military company draws on the same sort of body of evidence. That wouldn't be, we wouldn't object to that. And it would be appropriate for the court to look at those other aspects of the decision if it's so thought so. I think it'd be straightforward and easy for the court to look at just the residents in the zone as evidence that the company meets the term military civil fusion contributor, but we wouldn't object either way.
On the due process claim, Hesai contends that being designated a Chinese military company causes it to be barred from these various kinds of contracting. And I take it what they're really saying is that it's really reputationally harmful. And whether or not they plan to pursue contracts with DOD or contracts under the CHIPS Act, that is a legal disability, indisputably, and that where you have reputational harm and a legal disability, whether or not they plan to seek such contracts doesn't matter so much as that the investing public, for one, and various other material opportunities are affected in seeing that. So how is that not a deprivation of a liberty interest?
It's not, Your Honor. I think, as Your Honor recognized, the reputational harm, the stigma alone is certainly not sufficient. I think Hesai concedes that it has to. That's what Paul against Davis says. That's what this court recognized in Taylor. I think that to the extent Hesai is sort of vaguely gesturing to a plus, it hasn't really specified that there's any plus that's attributable to this designation, this 2025 1260H designation. All of these sort of generalized references to the investor's reaction, none of that's sort of traceable. And I think that's a traceability problem to the 1260H designation. They haven't pointed to any evidence that it was specifically tied to that. And to the extent they're talking about future opportunities.
They had a pretty sudden 30% drop in their stock value. Is there a temporal problem with that?
I don't recall, Your Honor, if there was any evidence that was due to the 2025 1260H designation that's being challenged here. I don't think that would be sufficient for giving rise to a protected property interest or liberty interest.
That they do, I mean, I think they've made an argument, and I'd be interested in any further response you have, but that whether they want those contracts or not, it is actually a categorical disability from participating in a certain kind of activity that might be seen as relevant to their business prospects, whether that's part of their plan or not. And therefore they meet that definition and they've been harmed.
I think, Your Honor, that, at least to my mind, kind of just comes back to a stigma argument. It's a reputational argument to say that business prospects are being harmed because of this designation, and stigma and reputation alone don't count. If they could point to a specific property interest, I think in the Iran cases, there were
specific liberty interest in the ability to not be barred from certain contracts.
If they were interested in those contracts, I think that claim as to the contracts.
Any case in which the person had to be interested in the contracts that they were barred from, or the jobs, or the opportunity, the profession, or the like. And if they aren't interested, that disability is not the kind that counts under reputation plus due process.
I think only two quick points here, Your Honor. One is as to those contracts. I think Your Honor pointed out earlier, they haven't identified any contract that they do intend to pursue. And in fact, they seem to disclaim that. I don't want to rest entirely on this case, but I'll point to it as a helpful fact pattern. In the DIN Atlantic case, the company had identified specific contracts that they had pursued in the past and had intent to pursue in the future with the government. And it was at the pleading stage. It's not really on all fours, but that's what the court found sufficient to sort of proceed with the subsequent inquiry. And I think I'll just make a quick point here about that subsequent inquiry. As Your Honor is aware, the due
I'm
process.
sorry, which case you said?
There's a case that the other side cites that we don't cite called Din Atlantic.
Din
Yes.
Atlantic.
And I cite that only for the.
Dine Atlantic. Okay.
Yeah, sorry, Dine Atlantic, I apologize. I cite that only for the point that the facts there were meaningfully different and involved the sort of intent to pursue a separate contract. I don't think you need that in the context of due process. I think the point, it's actually much simpler. They simply haven't shown a ripe claim here or any sort of standing to pursue that due process interest. And so I don't have that another case beyond that off the top of my at my fingertips, but I think that's sufficient. And there are plenty of cases in the ripeness and standing context that would support that doesn't support a due process claim here when they have no intent of pursuing any contracts with the government. You can't, I think it would be sort of illogical to allow a sort of intent, a non-existent intent to pursue those contracts to support a constitutional due process claim. As Judge Garcia pointed out, it would be an ill fit. You know, you pursue that claim if you intend to pursue those sorts of contracts, which they haven't expressed any intent to.
Further questions?
If your honors have no other questions, I'd ask this court to affirm.
All right. Thank you.
Thank you.
And did council reserve time for rebuttal? 2 minutes. Okay, we'll hear from you on rebuttal.
Thank you very much, Your Honor. I will be brief. I'll make 3 points. Number one, on the discretion point, because I think that is ultimately what this comes down to. Does the Department of Defense have essentially unlimited discretion? And the answer to that has to be no. I think my friend on the other side acknowledged that there's quite a lot of guidance in Section 1260H that requires the Defense Secretary to list people not based on whatever he feels is a national security threat, but rather he shall identify each entity he determines is a Chinese military company. And then Chinese military company is a defined term. So it is not an open-ended delegation of discretion to list some and not others. It is identify which of these companies are Chinese military companies, and those are defined in a specific way. Otherwise, there's no limiting principle. They can proceed as they go, depending on which companies they feel meet the definition. But that again runs right into the ACA international problem. I'd also point out that the agency itself did this in a specific way. It said, here's what we believe is the contribution to the defense industrial base, and here is what we believe makes you a military civil fusion contributor. So I would think there's a Chenery problem if you're starting to look outside what the two-step inquiry that they itself relied on. That would be rewriting the agency decision.
They also did look at all these 4 different definitions of being a contributor to the Chinese military civil fusion contributor.
Correct.
And why shouldn't we or couldn't we just affirm on that ground?
Well, a few reasons, Your Honor. Even if you were to find that one of those military civil fusion prongs satisfied the definition of or made Hesai a military civil fusion contributor, that still wouldn't solve the defense industrial base point. Again, the department treated those as 2 separate inquiries. Another point is that these were hotly disputed by Hesai below. The district court relied on the resides in the military civil fusion zone because that was the easiest one. The other ones had severe problems, such as, they accused us of advertising on a procurement platform, and we had evidence in the record saying that didn't happen. We never did that. So that's why the district court didn't reach those. Obviously, it hasn't been briefed either. So I think at a minimum, you'd have to remand on that basis. But I do want to, that gets my second point, which is that they keep talking about how we don't dispute that LiDAR has these military applications. We don't dispute this. We don't dispute that. This is an entirely one-sided record. The only evidence that we were able to submit to the agency happened before the original, happened in response to the original designation before we were given a copy of it. They refused to share the basis of the listing. So we sent a letter saying, just generally, we don't meet any of these categories. We don't even know why we were listed. So that's the record. Everything else in the record is their own material that they have compiled all along. And what the PMOI case says is that to the extent we defer to an agency determination, we do so on the ground that, or on the assumption that that the record is robust and that, due process has been provided to the company. So I don't think you can accept the fact that they've made all these findings on a one-sided record and say, well, under substantial evidence review, that's good enough. I mean, this really goes to the heart of the due process problem in this case. I guess the third point I would make, Your Honor, is on this record, there's really no dispute that Volvo and others satisfy. We've been saying that below. We've said it on appeal. They've never denied it in their briefing. Again, it's a one-sided record, so we haven't been able to put in records showing exactly their locations and all these things, but it's essentially undisputed for that. And I think it's the definition of arbitrary and capricious agency action to say that you both meet the definition, but we're going to add one of you and not the other. I think that is I think it's crucial as well that they, in their contribution to the defense industrial base section, they say that the the PLA uses LiDAR in its development of autonomous vehicles, which can have military applications. So they don't even say that LiDAR specifically has military applications. They say autonomous vehicles do. And to me, that opens up a range of companies. It's not just LiDAR. They didn't point to LiDAR specifically. They say autonomous vehicles are used by the military. And I think that's crucial because, again, it just makes this completely open-ended. It's not something special about LiDAR specifically. The very final point, I know I promised 3, but just the due process point, Your Honor. We've pointed, reply brief, page 30, note 4, among other places, we pointed to all the specific legal status changes that we have. We think it has to be the case that the stigma plus means we don't need to separately show we were going to pursue a specific context, because otherwise I'm not sure what the stigma plus framework, even what work it's doing. If we wanted a specific contract and they were denying it to us, we wouldn't need to show reputational harm. We would just go in and say, we wanted to pursue this contract, but you denied it. So, make sure, please let us, you've denied us due process by not letting us do so. I think the whole point of the stigma plus is that, you can't just show reputational harm alone. You have to show something more. And that's the change in legal status.
I'm sorry, you said that you weren't provided with the basis of the decision, but the decision is in the record. The basis is spelled out. It may not be, it obviously isn't satisfying to you, but they do say what they rested on.
Yeah, just to be very clear. So we were placed on the list, I believe, in January 2024. We asked the department for the basis of our listing. They refused. We then submitted a letter saying, here are all the reasons why we couldn't satisfy any of the factors. They did not provide a substantive response. We then sued them. After we sued them, we got a copy of the administrative record. So at that point, we learned the basis of the decision. Then we litigated fully through full summary judgment briefing. 3 weeks before the argument, they said, by the way, we're gonna come up with a new decision, so let's postpone this hearing. They retracted their original designation, which only listed one ground for military civil fusion contributor, which was affiliation with the MIIT. The chief industrial regulator. Then in their amended designation, apparently they scoured the internet and found 3 additional grounds. And that's why we're here today. At no point, though, was there ever a process by which we could supplement the record, why we could give additional information, we could show why their information was wrong. And that's what I'm talking about in terms of the kind of procedural irregularities here. And in fact, the chief evidence they relied on is an article that we got after we had filed our second summary judgment motion. They said, oh, by the way, here's the key evidence. At the argument, the government said essentially that was the only evidence that they had on the contribution to the defense industrial base. So they've also disclaimed the other 3 grounds as contributions, I think, below. And again, under this court's sort of ordinary procedures, that should be enough to say that can't be an affirmance on those grounds. We ask the court to vacate. Thank you very much for your time.
Thank you. The case is submitted.
This honorable court now stands adjourned until next week, March 24th, 2026 at 9:30.